Hi, good evening, everyone, and welcome to another edition of our Justice and Cases guest speaker series. Today's guest is a criminal defense lawyer. He has his own practice and is doing quite well for himself here. I'm really happy to chat with an old classmate of mine from time there back at Osgood, like a number of our guests. So thank you so much, Richard, for taking the time and joining us here today.
No problem. Nice to see you again, JP. It's been a little bit of some time.
So, Richard, maybe you could tell us about what, first of all, got you interested in law to begin with. Why did you go to Osgood all those years ago, and what have you been doing since graduating law school?
Oh, sorry. Some of the problems on Zoom. You're mute and you don't even know it. But it's funny you said all those years ago because some of the reasons that made me want to go to Osgood sort of sell out my age, but maybe not Osgood in general, but wanting to go into law. I got into law because I wanted to do IT and intellectual property. That's what I had a deep interest in. I had a deep interest in digital media, the internet, emerging of music, videos, and how this intellectual property was being spread around to people. Most importantly, I wanted to get in and fight the big guys that shut down Napster and LimeWire. So that's what I got into. But as time went, especially when being in law school, I did criminal law and then did crim intensive and evidence, and found that I was getting drawn into the law world. It was very interesting in terms of the facts of the cases, but more importantly, the applications of the law, the interpretation, and just generally the advocacy aspect of it. And so that was something that really drew me from the property, from the intellectual property law line. And I also found that with crim law, you get to the core of humanity. You learn a lot about the human condition and what motivates people, what makes people want to do things or not do things, and you're able to actually help them out while being a full advocate. And so that's how I got into criminal law, and now practice doing criminal defense.
Yeah, it's interesting. I think if I look at my transcripts, probably I have all those IP courses. And I thought, that's what I want to do, and then nothing like it in the end there. But got a good background there in like copyrights and trademarks, and I think I even did a moot on IP at one point. But I guess that's what's good about law school. You can kind of learn a lot of different things, and then you can find which one you end up doing. And it may even be different after law school. I think, did you article in crim then, I'm presuming as well? Or
Yeah, I had articled in crim, ended up getting into the crim intensive program at Osgood. And so I was there with some professors who are now judges. Professor Strobopoulos run that, and we also had His Honorable Joe DeLuca and also His Honorable oh geez, name slips me, but I'll let you know when it comes back. But in Crim Intensive, ended up doing a stint at the Crown's office downtown, and got to see Crim from the other perspective, which was interesting. Got to work with Crowns, got to work with the police, and when I articled at a pretty large firm, which was one of Canada's largest firms at that time, and it was criminal law. So we had a lot of work, had a lot of cases, there were a lot of lawyers, not that many articling students. So it was quite intense. But I did article in crim law, ended up working in that firm for some time, and then went out on my own and became a sole practitioner.
so yeah, so what was the articling experience like at a big criminal practice? I mean, I remember when I was articling, we had a very small place, but if I came like 5 minutes later than people from those firms, I'd be waiting hours because they'd be like, I'm here for this lawyer and I got this matter and I got this lawyer and this matter. And I'm like, oh, can you just let me go? I have one little thing here. If you're the first one in, you're gonna get all your matters dealt with right at the beginning there.
It was intense, and you're right. If I had to go in front of you, good luck, because I might have at least 15 or 20 matters to deal with before you go and deal with your one. And you had, I mean, you're looking at a firm that has about 30 lawyers or so, tons and tons of clients, a lot. And you have the specific court. So you have that one court and all the different matters in each and every courtroom. So be it bill court or set date court or drug court, you have your list of 30 to 40 matters every day, and you can't leave the court until they're dealt with. So there was a lot of work there. Plus, you have to coordinate with the clients who are at the court, coordinate with the lawyers. When you get back to the office, is a lot of work that goes on behind the scenes too, on top of the actual work we did in court. So needless to say, it was intense. Articling was intense, and working for a large firm, the good thing was you got you got quite a lot of good experience from a lot of the lawyers. Sometimes you be dealing with a client by sitting in on an interview, and the lawyer would assign you, let's say, to do the research on that case. You do research on the case. Next thing you know, the lawyer says, "Hey, you know what? You're doing that trial," and you'd be like, "Oh, I get to do it, all right." And so then it's one of the that was one of the best experiences, and I would say a lot of lawyers would find, at least in criminal law, whereby when you work in larger firms, you do get to actually run trials on your own as an articling student. So I ran about maybe 3 or 4 trials as an articling student. So that was quite quite intense, but it was a very gratifying experience.
Yeah, and I think we'll certainly talk about the sort of the contrast of pre-pandemic and pandemic practice in criminal law, but I think that you highlighted something. Certainly, set date court today, you know, is quite different now, and I think a lot of senior counsel who would have otherwise sent you to like Barry and then to like Collingwood and then to Peterborough or something in a day of dealing with all three of those matters, or maybe they were a little bit more coordinated where you were at because they'd have so many and they just have three articling students, one's in the GT, one's out of the GT that day. But what have you found about set date court in particular? And I can certainly talk about other aspects now in the pandemic. How are you finding dealing with your matters online on Zoom versus in person before?
That did court, awesome. Online, I couldn't have wished for anything better. It should have happened many years ago. When you're doing set dates, and if you're on the list whereby you're not specifically set in one court to do the matters that you have, you would have numerous matters in different courts. As a crime defense lawyer, you're jumping in the car, you go into the different courts. You have to get there at that specific time and sign up on the specific list and go through the ups and downs of information is not being in before the court, or your client is not there and you have to wait, and it was quite hectic. It could take your whole morning, if not sometimes all the way to the afternoon, to deal with just a few matters. But being online, you're not physically leaving your office, you're logging on, and as soon as you're done that one matter, you log on to the next court, and the lists are online. So you either sign up the night before, really early in the morning, and you're ready to go. You call your client, tell them to log on, they log on, and it makes, at least from my end, my perspective, set dates have become wonderful. I don't dread them as much. It takes a long while to get to Newmarket Court. It takes a long while to get to Oshawa Court. I would never go to Hamilton Court for set dates or anything like that. But all these courts that are far away, we don't have to drive to them, at least not for set dates. So we log on and get it done that way.
Now, with that, does that kind of open up other areas? Like you mentioned Hamilton there, but you'd be a little bit more hesitant to take on a matter or you might have to quote the client, an extra like $1,000 or something because of all that extra commuting you would have to do. Does this kind of open up doing matters in like Thunder Bay and like Napanee or somewhere where you would never really have otherwise marketed or reached out to because it's so far away?
Yes, indeed, it does. In fact, I've started doing some matters in courts out of town, Barrie, Sault Ste. Marie, Sudbury, places where I would never do any cases because they're far to drive to. And with the opportunity to log on, you're with the opportunity to log on and do proceedings via Zoom, it's made it possible to take on cases there and to do work in those far places whereby on a regular day I would not be willing to get to go that far to service clients up there. So that has been something that has opened up through the pandemic that way. So the digital communication with the video technologies has made it very possible for me to do bails, judicial pre-trials, and other hearings online in far courts, whereby it would be very difficult to get to physically.
Now you mentioned things like files and stuff, and one of the things I always thought was funny was um, disclosure, right? I mean, you'd get these CD-ROMs, and you'd have to first of all, you'd have to find like a USB CD-ROM drive if you didn't have it on your little laptop, and then get the figure out the your birth date of your client there to get the password, um, and then you'd have to print because initially they would just give you all the paper, right? Like hundreds of paper. But I guess the Crown's office wanted to save on the the environmental cost or pass it along to you if you needed to print it. But now you're getting things online. So maybe you can talk about how you found just getting disclosure, and is it coming quicker? And what's that like in terms of accessing the resources that they send out?
It's amazing where to start. Oh my goodness. Okay, I'll give you just an example. Brampton Court, let's just say. However long it'll take you to get there from Toronto, park in. Brampton Court is always packed. Probably one of the busiest courts in Canada, if I was to say, because there's Superior Court, there's civil matters, family matters, all sorts of matters happening in that courthouse. Juries being picked. The parking lot's always full, so you'll park in severely far. You walk from the parking lot into the court, go into the lawyer's lounge, get your jackets off and everything. You go back, you go into the court where you're dealing with your matters. You file a designation, speak with the Crown, address the matter. And the process there was that you could not get the disclosure from the court anymore, as they were no longer physically handing over the disclosure in the court. You'd have to go to a different room called the disclosure office. So you'd go to the disclosure office, whereby it's a lineup from here until I don't know how long, and you would line up. This is after addressing the matter, whereby you're lining up. Line up, you get the front, sign for something, get your disclosure, but you get a disc and you're not sure exactly what's on there. Sometimes they do give you a list on what's on the disc, sometimes they don't. And by the time you get into the disc, you realize, oh no, I'm missing X, Y, and Z. By the time you request the missing disclosure, it's either in the disclosure office or sometimes it's the Crown's office, and you physically need to go and get it. And it's the process was just very demanding. And for some unknown reason, sometimes you'd receive the CDs, as in the DVD ROMs. At other times, you'd actually receive paper disclosure. So sometimes you'd go and get a physical box of paper, which has become less as time goes, and the other times you get the CD. And it was very weird because on some days you'd go line up, spend an hour lining up, and they'll tell you, sorry, your disclosure is not available, but we'll advise you when it's available. And by the time you get to the office, they send you an email, oh, this disclosure is available. And the next time you send someone or you go get it, and that process happened over and over again. But now the Crown has developed these two methods that they use. There's the disclosure hub that's run by MAG, and that allows you to, as a lawyer, to log in, and they put all the disclosure there, and you could log in and get it. Digital disclosure, it's all PDFs, the videos, the sounds, the 911 calls, everything. It's all on there. As well, some of the Crown offices also use evidence.com, which is also very similar. You have the security process you go through, and then after that, you log on and everything is there. You could download it, you could view it there, and it's instant, and I like that process because I've found that even on being bail court with a very thin synopsis, barely understanding what the allegations are against my client, and within some correspondence with the Crown, I would have either the disclosure emailed or a link to where I could go and get it, and I would have a much more robust package of the allegations and the evidence against my client, which would help run the bill hearing a lot more effectively than if I didn't have it. So, in short, it's the process, disclosure process has become very streamlined and a lot better than it was before. And most importantly, time is saved. There was a lot of time that was taken up, lining up for disclosure that was not there or was missing, or a lot of other issues back in the day.
Now, I mean, let's just backtrack there because I know you mentioned interviews there, and I know my students that I have in my evening class are had just done interviewing clients, kind of learning the skills of that. Now, what do you find in terms of when you meet a client, let's say, whether they find you from your Instagram or online somewhere, or they're just friends of your previous clients, usually, that there's a personal reference. What do you do at that point where they say, Richard, I would like to hire you. I've been charged with drinking and driving, let's say, or you can whatever criminal offense. What do I need to do? How does that kind of conversation go into you meeting with them? And maybe you can also touch on, I don't know if you're still meeting people in person or you're doing it like this on Zoom, and making sure you get all the information out from your client. Hey, you're on mute there. I feel it's the line of like the last 15 months here.
I,
But
I swear, JP, I am not a cat. I am human. Can you hear me? You can see me. I am actually human. Oh my goodness, it never gets old, these technological issues. But what the process for me with regards to meeting clients or client intake would be the same pre-COVID as it is right now during the COVID, whereby the client calls you, I'll get them the name, the date of birth, I'll get the type of charges that they're charged with, and I'll go through a conflict check to see if they have any conflict with them themselves or the parties involved in the case that they're in. So either the complainants or co-accused or anything of the sort. From there, I would schedule a phone interview whereby I would get a little bit more information about the person and the charges, the next court date, and the type of releases that they're on, and other general information. And that would be the initial consultation, whereby then I would schedule an in-person meeting. And that's now where the divergence comes in between pre-COVID and COVID days. So um, in the pre-COVID days, I'd set up the appointment. They'll come to my office, bring their identification, whereby I'd verify who they are. They'd bring whatever documents that they receive from the police or the court, and what else that they have in relation to the case. Would do the intake there, and they would sign the uh, designations and retainer agreements there, as well whatever other questions they have, I would answer to the best of my ability. For during the COVID, now I'm not meeting clients face to face. Would meet through the Zoom, and all the transfer documents would be happening through digitally through email, and yeah, through email and email signing. And for identification, I would ask the client to actually put the identification by the camera as they put it next to their face, and I would be able to verify if they're the person who uh, they are. And that's how the intake process would go. And if it's a matter of case preparation or anything like that, again, most of the times through Zoom, unless it's in at the jail, whereby I'd be going in person. But we're not in a room with a table. We're doing it through glass if it's a jail visit. And so you have the telephone and you're doing it through glass. Pre-COVID, it would be in a table, you're in a room, and it's just you and your client. And some jails luckily have the virtual conferencing, so we could actually be in the they're in a room with a TV screen and a video camera, and I'm talking to them. They're able to see and hear me as well, I'm able to go through disclosure with them. And that would be jails like the South. And now I think ATRC up north has started, but not that many jails have the video conference.
And you find when you meet people for the first time here and they're telling you what happened and giving you the story, is there like some apprehension in telling you what happened, or are you trying to get obviously all the details and let them know, hey, look, I'm here to help you, but I need to know, so maybe we have a defense, or maybe there was a charter violation, maybe um, there's something that we can raise in terms of finding a reasonable doubt with respect to whatever the charges are, or do you have to kind of be very prodding with your questions, or do you just find that you just ask them some open-ended stuff and they just kind of tell you everything? How is it like kind of discussing with those clients what happened?
Most clients are very nervous. Some of them have never dealt with lawyers before. Others are just anxious to get their story out. They're anxious to tell what happened, where they were, what they did, who was there, and everything. And number one, I don't I care about what happened, but we'll get to that later. That's your version of what happened, but have to put the brakes on a lot of people. Stop, 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 stop right there. Let me see what the synopsis says. Let me see what the allegations are against you. Let me read and see what disclosure we have, what disclosure we don't have. And of course, by looking at the type of charges and the amount of disclosure that you have at that time, whether it's the synopsis or the statements and whatever other items you have, you're able to make a rough analysis of what the legal issues will be in general, at least at this point, and you're able to at least diagnose what other type of disclosure is missing, and then what things you would need in order to mount a defense if a defense is going to be mounted, and of course you're able to have a good analysis of the individual. So I don't want to hear anything that the client has to say, especially in the beginning of the case. Much later, I may ask questions, especially if the person will be taking a stand. But it's important to note that through the rules of professional conduct and other precedents, that as a crim defense lawyer, if I hear some things, I cannot unhear them. So I have to not only uh, be diligent while defending my client, but at the same time, I have to be an officer of the court and not purposefully purposefully mislead the court in any way. And so that is a line that I let my clients know that there's some things if they say I cannot unhear, and unfortunately I would not be in a position to help them at a later date if evidence comes out a certain way, or if I find out what if there's evidence to the contrary, strong evidence, strong and credible evidence to the contrary of what it is that my client adamantly says. But at a later time, especially when it's cases where one party says something happened one way and another party says something happened one way, that's a lot different than a situation where there's a video camera there that shows everything that happened, and then you're left with the question: is that you? or and why did that happen? And so these are the things that we get into at a much later date, and I do not have any issues prodding some people, unless it's some delicate issues where some people do not want to explain. And this comes much later, once you have the whole case and you're working towards this trial. That's the time that you'd have to focus on certain issues, which some people may not want to get into, especially when you're talking about charter defenses, whereby a lot of them depend on the client admitting that they were in possession of certain items at certain times.
So I guess maybe for my students to understand there that if a client comes to you and says, just kind of what you were talking about, hey, Richard, I did it, I was drunk, or I was just in a bad mood that day, and you're like, I can't unhear this, but are you still able to defend them? What can you still do, knowing that they've told you that they are responsible? I mean, what is it that you can do? What is it that you can't do as their counsel now?
Sometimes absolutely nothing. Sometimes, I mean, if client's coming into your office with the bloody knife and saying, "Here it is, I did it," then you're automatically disqualified as the counsel. You would have to get counsel on your own and try to figure out how that situation will go. That's the Murray situation from way back. But uh, a lot of times, again, there a lot more issues than the factual guilt itself. Like I said, if there's video evidence showing a certain situation and it's very clear it's in HD, that is the person. They're doing what it is they're alleged to have been doing. Uh, we don't know what the state of mind was. We don't know what happened before. We don't know what happened after. At least if it's that's just that certain clip that we're watching. So there's a lot of things that go past the admission of factual guilt per se, by from the client. And again, with defenses, there are tons of them. And when it comes to things against things such as constitutional challenges, whether it is you're challenging the law or whether you're challenging how the law was administered, say the charter challenges, you a lot of times in the court in the case you do admit your client would admit and you would say, yeah, no, that was my client. Yes, he did that. Yes, they did that. Yes, they did that. Yes, they had it. Yes, they said that. However, there was that 2 hours that they were at the back of the building before they got into the police station. Or at the police station, they got into a room. It was dark, and some officers had their way with my client before they got this confession. Or the officers executed a search warrant in a certain way. Or officers had a search warrant that was invalid due to other constitutional issues. So there's a lot of defenses, especially when we're talking about charter defenses or constitutional defenses. Again, when you're actually fighting the law, you're saying, yes, my client did it, but no, no, the law here should not be such. And that allows, at least for that part where the client has admitted that it was them that did everything they wanted to do it, allows you to defend them. Otherwise, in some other situations, doesn't quite work out. Say a client comes to you and says, "No, no, it was not me. I was at JoJo's house. And call JoJo right now." JoJo's like, "Yeah, I was with her. We were just doing nothing." And then at a later time, video disclosure shows up and
Yeah, and then they
miraculously,
come to court
person who
wearing the
looks like
same.
your client, person who looks like your client, the person who looks like JoJo, were there at the time at the place, and unfortunately, it's very difficult to continue that relationship with your client, whereby they have stepped on their own foot by lying to you and telling you one side of the story, and
And then
then
they show
now
up to court in the same clothes that the video is, and it's, well, what do you do now?
that has happened. That happened before. I mean, a lot of times is in that situation, as I said, if they tell me something and I'm seeing something that's completely different, I'm like, get another lawyer, sir. I can't help you. Like, you said, you swore to me, you told me you were with JoJo. Now I'm seeing the video here. It looks like you and JoJo are at the bank, guns out, HD. Look at this. Look at all these angles. It looks like you. Maybe it's not, but sorry, I can't help you. I can't go to court and say one thing, and you can't take the stand and say what it is that you told me. So there's a lot of boundaries there to be careful about, and of course, there's the most important uh, relationship I'd say in any sort of any sort of law, which is the solicitor's client privilege relationship. And with that, some lawyers may take the some lawyers take the actual complete opposite direction. I remember once being at a speakers event with Eddie Greenspan and Brian Greenspan many years ago. This was a law garage, and they both brothers, both amazing lawyers, took completely different views. I remember Eddie saying, listen, solicitor client privilege is what it is. It's ironclad. It's stuck. It's a privilege, should never be pierced. When the client comes in, I want to tell me everything, everything. I don't care. I want to hear it all so that I could help you better. And of course, his brother, that one I remember him saying, no, 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 no. I don't want to hear anything. I actually don't care. And I would take the Brian Greenspan way, which is, again, I don't want to hear it. I don't care. We'll deal with this at a later time once we've reviewed everything and you'll answer my questions as I ask them. And at the end of the day, it's the client's decision whether or not they're going to take the stand or not.
That's certainly interesting there, and everyone will have a little bit of a different kind of layer or take on what to get or what to find out and when to find out and how to find everything out there. Now, would you say kind of the clients there, like in that example there, is that the biggest challenge you find being a criminal defense lawyer, is kind of working with this big variable? You don't know what they're going to say or how things are, or do you find something else more challenging with respect to practicing in criminal defense?
I mean, that's a challenge on its own, but in crime defense, I would say, yes, dealing with client management is one thing. It's definitely a challenge because you want to stick within the ambit within the law, but at the same time, you want to defend your client to the best of your ability. You have to take all the rules in hand, and you have to basically balance what your client wants versus what it is that you could do. Again, as a lawyer, your client is your boss. However, you're also guiding them with the options that they have, and you're giving them the best legal advice you could at that time to help them in their situation. If you get to a point where client will not take your legal advice, at that time it makes it very difficult to defend that person. And sometimes I would remove myself from the record, or the client would then agree to go a certain way. But the things that I find challenging past being a criminal defense lawyer is not only balancing, uh, as in client management, dealing with your client, but it's also balancing other interests. You're in the court, you have to balance interests of justice while you're in the court. You have to, of course, be straightforward, honest, candid, and not mislead the court in any way. You know you want to win for your for your client. You know that the law, it leans a certain way, and you have certain cases that will help advance your position, help advance your case, help the case advance for your client. And if you go to a judge and you say, "Hey, Your Honor, here's my casebook. All 13 cases lead towards the proposition that this is how things should go, and my client should get acquitted," knowingly, you yourself as defense counsel, knowing that another case came out from the Supreme Court, maybe yesterday or the morning of or something, and it changed, or the Court of Appeal, and this changed the law altogether, or it takes a completely different position from the cases that you've given the judge. At this point, you have to be honest. You have to let the judge know this is there too. This has happened, and maybe the law is not how it was before, and it's like this based on this new case, and you give it to the judge. Let the judge decide that, but you cannot mislead the judge. You cannot mislead a jury. You cannot be too. You just you have to be fair. You have to be fair, reasonable, and truthful. And so those are some of the challenges, because that means that you have to be on point with your research. You have to be on point with your time. You can't spend the whole time on your case dealing with your client who's calling you asking you when's the next court date and what's happening here, what's happening there. Meanwhile, you know that they're not going to be taking the stand, or you have a lot more research to go, or you don't have the requisite disclosure of which they're asking you about. So that, in addition to client management and and managing client expectations, which is very important, you must also balance the time that you're working on a file. Some files are a lot more complex than others. Some cases are a lot more complex and take a lot more work than other cases. And so it's important to, I find that the time management there makes it quite difficult because you might focus on something because it's a very interesting topic and you're really into it. Meanwhile, it takes away time from another case that's a lot more complex, more difficult, that needs your time. And then, of course, there's clients. Some clients are awesome. They give you a call. They only speak to you once in a while. They're not around all the time. But you have other clients that are calling you all the time, sending you texts, emails, all the time about everything. So it's important to manage expectations, let them know when you're available, what you're going to be talking about when you're dealing with their cases. And of course, it's important to uh, let the clients know that you do not have control of the outcome. And that's a very stressful issue in crime defense law because the stakes are quite high. Some people may go to jail and may go to jail for a long time. They may lose their liberty, they may lose a lot of money. And so what you find is the, or at least what I find is when I do not have the control of the outcome, which is you may be found guilty, you may be found not guilty. It becomes very stressful because we put in all the effort that we could. And once that case is over to the judge or the jury, we have to wait until the decision comes. So the thing that I do to overcome that difficulty or that fear is put the best foot forward. We do hardest, best research we could, put in all our efforts on the case, look at all the different angles, consult with many other senior counsel, and just basically do the best that we could in every case so that we know that at least no matter what the outcome, we did everything that we could. It's not a situation whereby when it's done, you think, oh, maybe we should have called this witness, maybe we should have done this, should have done that. That becomes quite stressful.
So how do you deal with all that? I mean, you have this stress. I mean, it's busy. You have clients maybe needing a lot of attention. You have so much weighing in on the outcome. How do you manage? I mean, one of the things we talked about in the last week was a mental health week there with the Law Society, and I know they have a couple of CPD, a couple of days of CPDs coming up. I think it's this weekend or early next week. How do you kind of manage all that and take care of yourself too? Because I mean, at the end of the day, you're going to go home and well, I guess now you're in home, so it's you move to another room in the house. But and you say, okay, I got to forget about that. You know, we weren't successful, and you know, my client may be going to jail, or it didn't go as well as I thought it would go, or just having that pressure before trial, knowing, well, look at what uh, lies in the outcome, right? And how do you kind of manage all that and focus on your own life afterwards?
If it is a loss, in some cases, hurt a lot more than others. Uh, Whiskey always helps. Gin sometimes, but past that, what happens is, um, as a crime defense lawyer and anyone in litigation, after years of experience, you realize that that win is just as good until the next case. That loss is just as good until the next case. And this is because once that case comes to an end, you may be feeling very happy. You feel that yes, we have victory here. We've accomplished something really great here. Till you get the next case, new challenge, new beginning, and that starts, and the whole process starts again. And you lose, and you feel very bad, and you're back again to try beating yourself up. One thing you got to realize is don't beat yourself up because some you win some and you lose some. And what happens in between all of that stuff, as much as it's easy to say but hard to do, time is probably the most important thing that lawyers have to offer in general. We don't have goods to sell, don't have shoes, don't have any physical things that we're given except for our time. And so when you're dealing with client, when I'm dealing with clients, it's important that I let them know what the ground rules are from the get-go. You talk about when you could receive calls, when you don't receive calls, whether you do receive texts or not, whether you deal with emails and what times of the day that you deal with emails. And with litigation, especially in crim, we're in court a lot. So I advise the clients that during the day, a lot of times I'll be in court. So unfortunately, I will not be able to deal with you at any given time during the day. At a later time, I'd be able to deal with you. So that's important to just set certain boundaries in order to afford time for yourself. So I take time for myself. I take time to try to be physically active, to go out and enjoy the beautiful sun as it blazes through the windows, but also taking time to be with family. That's something that is very valuable, and you'll never get that time back. And on top, so those two things, taking time for self and taking time for family, I find sort of help me recoup myself. They help ground me and get me back to being in a good position whereby I feel mentally fit and I could help other people. It's very difficult to help anyone if you're not in a good state of mind yourself. And that's something that I find definitely helps out. Taking time for myself, taking time with family, and sometimes I do these blackouts whereby um, no blackouts from the whiskey, blackouts from media, blackouts from the phone, blackouts from email. Basically, I unplug myself for a day or two or a weekend, and I let other people take care of my matters through those couple of days or weekends that I'm taking time off to be with family or friends or myself, and I focus on that. And when I'm ready, I get back in, turn phones on, turn computers on, and get to work.
Yeah, sometimes it's important to obviously know when to take a little recharge there and then get back at it ready to go. Before you were mentioning about charter violations and like the police could have done something. Certainly, we now live at a time where a lot is being captured on phones, and before it was very difficult to go into court where your client is saying the officer did this, and the officer's coming in years of experience testifying, and you're asked to make credibility findings, and it's very difficult for a judge or a jury to believe your client. Now, how do you find kind of dealing with that in the backdrop of everything that's been going on in North America, and advancing some of these difficult, you were talking about zealously advocating and fearlessly advocating for your client, but to have those uncomfortable lines of questioning, and how do you kind of do that, and um, regardless of obviously the allegations that are being levied, how do you fight through that and raise that in court, and certainly if you're not able to do that, maybe you shouldn't be doing criminal defense, right? But what is that like when dealing with those situations, and how does that make you feel personally?
It's it's definitely difficult. It makes it difficult when there's certain evidence against your client, but it is there, and you have to deal with it. What I like about social media nowadays on the phones and video cameras is that a lot of the things that used to happen behind the scenes are now happening up front, and everyone could see that not all police are quite honest. Some police officers do lie, and other police officers back them up in the lies. And unfortunately, these type of things cause injustices in the system because you find an unsophisticated client who has never been in courts before, or who's involved in a certain type of underground lifestyle, getting into interactions with police, and then they're them being honest and stating their version of what happened, and of course, these officers stating a complete different version of things that did not happen, and they end up being believed over your client who's not believed. Maybe it's because they're not quite professional witnesses, or they are just unscrupulous characters. Some of them are involved in certain things that many people may not view as morally right. And the good thing again with the cameras coming out, you're able to see things in an objective way. This is what we saw. This is what has come out, and that assists a lot. And what um I find that way, at least when that type of evidence is assisting my end, is I try to take it and use it to the best of my ability. If it does not assist me, I mean, it's there. If I'm defending the person that's alleged of the offenses, uh, do my best to defend them, even with that evidence there. But I'm happy that it's there. I'm happy that people are taking on the time to tape themselves. I mean, to tape interactions between them and police, or interactions in general that are happening, and it helps. Uh, it helps give a at least an objective evidence, an objective point to whatever it is that you're seeing through the video evidence. The thing that really upsets me is when people cover up, whether it's complainants covering things up, or whether it's police covering things up, whereby they have seen somebody completely do something wrong and they're not speaking up about the wrong thing that they saw happening. They're not speaking up against their fellow officer or their fellow friend because it's part of a code that they have to live by. It really upsets me, and it really makes me happy when I see the videos out there that are able to capture those moments. It upsets me because it's an injustice, and like Martin Luther King said, injustice anywhere is a threat to justice everywhere. And this injustice, at least in systems such as the criminal justice system, happens when you see something wrong and you don't speak up. If it's a police officer seeing another fellow officer doing something wrong, they don't speak up. Uh, Definitely causes an injustice. If it's a crime defense lawyer who's seeing another lawyer do something that's not right with regards to their client, it's an injustice. When a crown sees something that's completely wrong, or uh, not right, and they don't do anything about it, or they try to cover up the colleagues' mess, or their own mess, or a police officer's mess, it's an injustice. Hope that answers your question there.
Well, no, it's like there's certainly in our system, there are a lot of injustices, and predominantly, we're looking at it from a situation that it affects racialized or minority groups a lot more differently than others, and certainly part of that conversation of changing the system is having more diverse counsel and people involved with the system. And so, how does that feel there? I mean, being a criminal defense lawyer now, I think on 10 plus years, which I feel older every time. My students always crack jokes um, now because I always like to think of myself as being really young, but I realize I'm pushing close to my 40s. Law school was a long time ago when we would go eat at Swatow and have our time there in our youth. But I mean, does that kind of, when you look at it, you look at some of the stuff there, and that's it's important for us now to be part of the system, because we can show to the next generation, look at what I'm doing, and look at what you can be doing, and you can relate a little bit more to some of those things when you were in younger, right? In terms of what it was like. So, what is that like in terms of seeing more diversity in our profession, and what more can we do to really push that forward, so that our justice system, and those involved in the justice system, kind of represent what society looks like.
Wow, complex question. Well, when we first started, just a few years back, I don't know if it's as many as you say, but when we graduated from law school and got into practice, and I felt as though it was the same situation in other practice areas, because from law school, people going to work, and most of the times the representation in law school is what you end up seeing at the workplaces, because the lawyers come from the law schools to the workplaces. And at Osgood, yes, we had some people of color, we had um, different people represented, but not as much as we would have liked. That was the same situation I found in the workplaces. In law, there was not that many black lawyers in criminal defense. There was not that many black female lawyers. There's not that many people of color. You'd see them here and there, but and also not as many crowns or as many judges. As time went over the years, it's become better. I have to say, I've been very happy to see some uh, colleagues of mine and people that I knew getting appointed, and I saw the even the Court of Appeal becoming a little bit more diverse, Superior Court, different courts of Ontario Court of Justice, judges being appointed, and that has been good, and I've been able to see a few the numbers rise with regards to people of color, black people, and people of color in general, and unfortunately, it's not as much as I would like. I find things such as mentorship come in handy there. So if there's people out there in the community, it's important to have speaking engagements that help them. It's important for people to also join communities such or organizations such as Cable, like Canadian Association for Black Lawyers, whereby you'd have a group of lawyers from all different types of fields, and you could contact them at any time, get mentors who will guide you through the process of going through school, law school, and becoming a lawyer. And I find that such organizations help. Law Society does have a Black History Month event that they try to help, and as time went, I mean, they're trying, but not not as hard. Anyways, it's a difficult question with regards to how I don't know. Short of trying to be a mentor for the younger kids who are in high school, middle school, university, undergrad, law school, and just try and let them know that you could be a lawyer if you want to. This is what you need to do. And stick with it. I can't really get into much more, but yeah, there's a lot more that needs to be done. I don't have all the answers, but I do my parts where I can.
Yeah, I certainly think it's not like something that we can one day just wipe. You snap your fingers like Thanos or something, and then here we have complete diverse representation overnight. So I mean, I think progress comes in little pieces, and you're right. I think it's going out to those in high school and maybe even in undergrad as well, and sort of mentor and provide the connections so that they can come into law school and go through law school and succeed. And we'll see what those results are, especially given the cost of school these days. It was pretty expensive when we went to, but I think it's like way more than that now. Now, Richard, in terms of your practice and everything, and so we were talking about challenges. One of the things that criminal defense lawyers often get knocked on from the public is, how do you sleep at night, or how do you represent those individuals? Where you come up with some technically, we were talking about, like, you can still represent them if they tell you they did something, but you have some technical defense, or you raise a Jordan delay application or something, and maybe factually they may have done it, but you just help them get away with whatever. How do you respond to that criticism that often comes about criminal defense lawyers, and what is your answer to that?
Well, how do I sleep at night? Quite well, very very well. A little too much sometimes. How do I defend some people? It depends if they paid or not. And but in general, everybody deserves a defense. What I have learned over the years is never to take things too seriously. Don't take yourself too seriously. Don't take your client or your case too seriously. Every case is its own, and you do the best you could in that case, and you get on to the next case, and you do the best that you could. A lot of our cases are difficult. A lot of our clients are in a lot of hot water. Once in a while, it may not be them, it's somebody else. However, in a lot of the cases that I get, it, especially as the years go, are more difficult. But it's important that I always keep my head up and separate the person from the action that they're being charged with, and also separate myself from the work that I'm doing. In the end of the day, no matter how many hours per day or how many hours per year I'm spending doing case law, it's still a job, still work, still. It may be very difficult when I'm at home in the middle of a jury trial because in my head I'm calculating things. I'm on the phone. I'm doing emails. I'm doing client interviews, and I can't get it out of my head. But after all that is done, it is just a case, and I'm doing the best that I could for whoever it is that hired me, no matter what it is that they're alleged with, um, to defend them. Everybody deserves a defense. We criminal defense lawyers must uh, zealously and advocate for our clients, zealously advocate for our clients, relentlessly, if laws to have any teeth. If laws to have any teeth, if there is to be any sort of strength to the charter, if there's going to be any constitutional challenges that have any meaning, defense lawyers must uptake that work. If there has to be any sort of testing of evidence or testing of the criminal justice system, criminal defense lawyers must do it. So, again, as I said, I do my best in every case. Of course, they must pay, but I do the best for every client, no matter what, because it's my job. And at the end of the day, I sleep quite well, except for when the jury is out. It's very difficult to sleep. Actually, the end of any jury trial, when you're coming to putting the whole case together, the submissions, and doing your close to the jury, and then the case goes to the other side, does the closer jury, and you're sitting down waiting for the jury. That time it's very difficult to sleep. I hardly ever sleep.
Now, Richard, thank you so much for taking the time here and joining, sharing some more insight here in the world of criminal defense. Always great to talk to criminal defense lawyers in particular. Always interesting. I think maybe I'm a little biased. I think I've been interested in criminal defense since I was like 10 years old. And I think a lot of my students certainly want to get into criminal law in some capacity, whether they could be paralegals for criminal defense lawyers, or they can have their own practice in summary matters, given their limited scope. So, any final words of advice for if you could think back to the Richard from Section D there, I believe Section D at
Yeah,
Osgood in 2006, there in your first year. And to my students, they're kind of in similar paths. Any words of advice? So we were just talking about mentorship. What would you say if they were interested in getting into criminal law, and what advice do you have for them? Thanks again for joining.
no problem. Well, the first thing I would say is, especially if you're going to be conducting anything digitally, is be careful what your Zoom name is and whatever picture is showing up on your Zoom. Do not show up as a cat, and do not show up with funny names. Past that, in all seriousness, there are challenges in any type of law that you do. You must be passionate for. If you're going to do criminal law, you get into it for the passion, not necessarily for the pay, at least in the beginning. So you must be passionate for what it is that you do, and you'll find in a lot of law, it turns out to be the same. When you're starting off, it can't be about the money. Not when you're starting off. It's about what it is that drives you. What is it that would make you sit in the office for more than 12 hours a day? Um, it will be challenging, but see it through. Just get it done. Learn from your mistakes. There's a lot of failure. There's more failure than there are. Uh, there's a lot more failure than there are wins, so to say. And most importantly, when in doubt, ask someone. When faced with a problem, ask someone, ask senior counsel, ask for advice. When you're faced with a legal issue or problem, whether it's personal or legal, again, ask for help. The criminal bar is very collegial, I find, and people are very ready to help you to get you precedence or guide you to the right direction. I would say the last and final thing, probably the most important thing in any sort of law you want to get into, no matter what level you want to get into. If we're in a classroom, I would say look to your left, look to your right. Remember those faces because at some time, those people are going to be your court staff. They'll be the court guards. They'll be your clients. They'll be the crown. They'll be your colleagues. They'll be your partner. They'll be the judges. They'll be the Supreme Court judges. Most importantly, well, at some other times, they may be your boss. So be nice. Be nice to everyone. Do not take things personally. Be tough, be adversarial, be cordial, but be nice to everyone. You just never know uh, who will be who at any given time. And I've seen this all through days of law school to my years through the practice.
Sounds great, and again, always great to see. Certainly, we can echo that because me and Richard go back to law school, and a lot of the people that certainly I'm going to share with you. I remember some of our colleagues that have also been on here, but that's I mean exactly. I mean, I'm sure maybe if I asked Richard, I didn't know him, he probably would do it anyways. But a lot more likely to join and reconnect there. Partially because we had those experiences, and I know it's really challenging for my students because it's remote. I couldn't imagine law school if we were on Zoom. So I have a lot of admiration for all those going through school right now, whether it's law school or college or university or high school even, because it's harder to make those kinds of connections that are really important as well. Because, like Richard said, you don't know who you're going to encounter later on. It's a very small bar, and your boss today might be the person you're arguing with in class about charter rights or something, so you better be careful. So thanks again, Richard. Thanks everyone for tuning in again. Been another great week of amazing people. We're into the 300s now since we started doing this in March, and we got a lot of them now recorded, so hopefully go through. I'm going to try to this weekend and certainly try to catalog them a little bit, so you can look at all the criminal people, you can look at all the immigration people, and kind of have a gather through all of them and learn a little bit more of an area you're interested in. So all the best.
Well,
Thanks, Richard.
thank you, JP. And just to finish off, this whole thing I'm talking about, you never know who's gonna be who. I'd forgotten the name, and that was Justice Enzo Rondinelli. He was one of the professors that we had in crim intensive, and he was a really amazing prof. And he was also a practitioner at that time, practicing in law while teaching, and he ended up being a judge. So I'm happy that I wasn't that much of a headache when I was in his class at that
Yeah,
time.
probably happy to give him like a 1 star. I'd rate my professors or something.
Exactly. So be nice to everyone. Thanks, JP.
Thank you